Hi, Elizabeth.
Hey, Sandy.
Welcome, everybody, to Health Law Simplified. We're really excited to be here for our 10th episode.
Yeah, we're wrapping up the year. It's been fun. I'm really glad we did this.
Yeah.
I've learned a lot. It's like just the reflection that goes into preparing has really deepened my understanding of issues in our practice area. So this has been, at least for us, I hope someone else has benefited, but I feel like for us, it's been really valuable.
Yeah, it's been really fascinating to watch how themes have reappeared over the course of the year. And, for folks who are listening, today's episode is going to be a roundup and, a retrospective through the topics that we've covered since episode 1 at the beginning of the year. And it is really fascinating to see how things have changed and what things are, ever present in this
Mhm.
healthcare industry.
Yeah, yeah. So the most interesting development in the last week for me, I know we have a proposed rule and a bunch of RFIs, but I think the most fascinating thing to kind of cap off the marketing theme for the year, which has been really interesting, was that CMS memo to the state insurance departments that came out on December 4th, saying that it's funny, they said they think it's likely preempted the state directives stating that practices including taking MA plan commissions, sales commissions down to zero mid enrollment season, that is an unfair trade practice. And there were at least 6 states that did that. I might not have the count exact, but CMS said this is an area of federal law. Preemption is very broad and you can't do this. This is our jurisdiction. I think CMS is solidly right on the legal question about preemption. There's another, bigger question about whether those are, ethically unfair trade practices and should be regulated by the appropriate body, in this case, CMS. But that was just a fascinating development. And to think that we've come from, we're talking about the beginning of the year, the lawsuit, the DOJ lawsuit about inflation of commissions to manipulate sales and to steer people into certain plans based on something other than their best interest. And then now there's this debate over the opposite. Can you drop commissions and make it harder to enroll to steer people away from plans? So that's quite a 360, 180
Yeah.
in a year.
Yeah, it really is interesting, just to respond to your point about how CMS was a little wishy-washy with using likely preempted when really I
Yeah,
can't
what?
think of a stronger case for preemption, but I'm guessing they don't want to take on the state insurance departments in
I don't
terms
know.
of all of their consumer protection
Yeah.
statutes, which I think CMS, one thing we know from the proposed rule for 2027 that just came out is that CMS is very much still interested in punishing what they call the bad actors in Medicare Advantage marketing.
Mhm.
And, to a certain extent, states are, they at least have overlapping interests in
Mhm.
that. So it's a little bit of a tricky road for CMS to walk with enforcing its, federal supremacy, but also, partnering with states in getting to the bottom of this kind of confusing, potentially misleading engagement with seniors.
Yeah, absolutely. But just what a reversal
Hmm.
from this kind of gold rush, sweetheart deals with FMOs to try to get them to put people in your plans to this in a not very long period of time.
Absolutely. To give a little peek behind the curtain to people who are listening, we were originally planning to record this episode last month, November, before Thanksgiving, and we ran into some technical issues. And while revisiting our notes, I, flagged not one but several areas where there have been substantive developments just in the last 2 weeks, and this is one of them, the marketing preemption issue that you just referenced.
Mhm.
So before we dive in, I know we've already, we can't help but talk about the substance like the nerds that we are, but we like to start with a positive focus. Is the preemption memo your positive focus, or do you have something else you want to bring?
I think I'm gonna use that. Yeah. I appreciate clarity. I'm not a politician. I kind of say things as I see them, even if I know it's a hard truth. And so I really appreciated CMS just clearly and accurately stating that federal law preempts state law on matters of Medicare marketing, because if they allow that to go on, again, setting aside what the policy should be on commissions and sales practices, I can see how that would just muck up the already very complicated exercise of operating and marketing Medicare plans. If, 50 different states plus territories had their own take on different issues and you were having to keep track of bulletins and depending on where you were and what if you have a plan that covers multiple states. I mean, we don't want to go there. And so I think, as a lawyer thinking about the legal issues, not the policy issues underlying it, I think that was really important.
Absolutely. And my positive focus is similar. And it's that we did get that proposed rule for
Yeah.
2027, on the expected timetable late in November. I was getting a little nervous, that perhaps the timeline would be impacted by the government shutdown. Now the government's up and running again, and we do have a proposed rule. And although it looks like there will be some significant changes on the horizon, just the fact that the administration is sticking to the usual process for putting these new rules into place, and also
Mhm.
we'll talk about this more, but seeking engagement and feedback from the industry is a really positive signal, and should help with at least stability and certainty going into the next year.
Yeah. Yeah. One, I'm jumping to another topic, as you mentioned, the proposed rule. Another dynamic that we're seeing is things like, because we're regulatory lawyers, typically when we're looking at proposed rules, we're focusing on legal risks or operational challenges, things that are going to be more difficult to implement than the policymakers, the regulators might have realized when they made the proposal. That's not what we're seeing here, and that's often what we're drafting when we're drafting comment letters. Here, we're seeing things that are business risks, so changes to the star ratings, where it really is in the interest of plans and associations and advocates for plans and other ancillary businesses in this market to study those proposals in depth and use the opportunity that they have between now and January 26th to make their case, especially on things that are going to affect their bottom line. And there really are proposals that will.
Yeah, that is a great shout out, just so that people know, if you haven't already taken a look at those requests for information, CMS is looking for input on future changes to the risk adjustment program and to network adequacy rules, star ratings, as Elizabeth just mentioned, really significant issues that affect a plan's bottom line and member care. And yeah, you don't want CMS making big decisions without your
Mhm.
input.
Without input. And especially, feel like we're at a tipping point in the marketplace. We had a whole episode on plans leaving the Medicare Advantage market
Hmm.
and some of the large departures. I saw one statistic that maybe 10% of Medicare Advantage beneficiaries lost their plan this year,
Oh goodness.
and had to enroll in a new one or return. So that is a new development. But if you are with a community-based health plan or an organization that represents them or a mid-size health plan, helping the regulators understand the impact of proposals on your organization and the potential, I don't know, anti-competitive? I don't know if that's the downstream effects, I'll put it that way, of some of the changes when you have very large carriers with bigger infrastructure, and in many cases, I think it's fair to say higher risk tolerance and willingness to take on the government. Um, are we going to see reforms, quote unquote reforms that continue to push smaller players out of the market? And I hope the answer is no. But I think that's a very important theme for smaller and mid-sized plans and those who care about them to put into those comment letters.
I absolutely agree. We can't assume that all plans' interests are going to be represented by the actors that have the infrastructure in place to file a comment letter on every
Mhm.
proposed rule. As an example, the agent broker compensation rules that CMS put into place last year and have since been invalidated by a federal court. But we learned that larger and smaller plans had very different reactions to those rules,
Mhm.
with some of the larger plans really pushing back on CMS for overreaching, which is what a court ultimately found did happen. But some of the regional plans and more community-based plans really were seeking a rule like that to level the playing field. So yeah, we encourage listeners to think about how these proposals uniquely affect your organization, and don't assume that an industry group is going to get that out there for you.
Yeah, yeah, very good point.
With that, do you want to, we've already touched on some of the themes. Do you want to just walk through the episodes that we've done and just react to what we said? Say, what did we say that we stand by, and what would we change? Now that it's been a year.
Sure, let's do it.
Great. So, episode one, I don't remember when it was published, if it was January or if we took a little bit to get going, but our first episode was titled Making Peace with Uncertainty, and that was our
That still
theme.
holds. That still holds.
Absolutely. And we identified some hot button issues for managed care in 2025. I remember, Elizabeth, you really gave some time to talking about the pressure on Medicare Part D premiums due to the Inflation Reduction Act's enhancements and really complete redesign of the Part D program, and the potential impacts of that, including beneficiaries shifting into Medicare Advantage, challenges to the Med Sup program, and I was wondering, do you have a different perspective on those shifts now?
Yeah, it's interesting. From a consumer perspective, when we talked about that last time, and in particular, the new, very beneficiary favorable before you take into account potential premium increases in the future, the cap on annual out-of-pocket costs in Part D is a game changer for patients and beneficiaries. I have seen that as a caregiver. I have seen that as the family member of a primary care physician. That's making a difference in people's access to medications, especially some of the more expensive drugs that are available. I continue to worry about the downstream impact on Part D premiums, but my feelings about it are mixed now that I've seen what a meaningful benefit enhancement that is for Medicare beneficiaries.
Absolutely.
So it's funny when you have this objective, oh, I'm concerned about premiums and, oh, this demonstration premium thing is a band-aid. And then you see the difference it makes in someone's life during the year, especially, once they hit, if they're not using the smoothing or whatever we're calling it these days, M3P. And then you go to pick up the supplies and the drugs and the cost sharing is zero. That's pretty amazing.
Yeah, it's that's been a benefit that advocates have really been pushing for a long time, and it's nice to see members benefiting from that. I do
Hmm.
worry about what happens when that demonstration program expires. I
Me
know that
too.
the Trump administration did keep it in place, but they cut some of the funding, so it's not quite as beneficial to help plans offset costs as it was. And there is a ton in this proposed rule about the Part D program, not just implementing the changes from the Inflation Reduction Act, but also, filling in gaps and adding details that weren't addressed in the statute. And there may be an opportunity to address, forward going concerns for plans who are still going to have to figure out how to make this something that they can pay for long
Hmm.
term.
Yeah. The other thing we talked about in that first episode was pressure on the med sup risk pool.
Mhm.
And we've heard more about that throughout the year. I don't think I would change anything we said, but we have heard about med sup carriers really struggling with cost this year, especially with some of the supplies, the wound, skin substitute, really expensive wound care that is an issue in original Medicare that's subject to some of the wiser reforms where they're putting in place prior authorization. Those things, even though med sub carriers are picking up the 20% or whatever the cost sharing is for that setting, that is affecting them, their bottom line. Typically, med sup has been a pretty not a huge moneymaker, but a pretty steady source of margin, and that's under pressure. We also I posted about this on LinkedIn. I kinda went down the rabbit hole of med sup guaranteed issue in connection with significant network changes and special enrollment periods for Medicare Advantage that also trigger guaranteed issue for Medicare Supplement. And we reviewed the standard notices that CMS puts out for plans that are either exiting a market or that have a significant network change. And they give guaranteed issue rights. So it's going to be interesting to me to watch. We saw in this year, in last year's annual enrollment, a drop in the rate of growth for Medicare Advantage. There was still growth, but it was slower than in previous years. And as more and more people who have been in Medicare Advantage for a while have this guaranteed issue opportunity to go into MedSup, even if they're in a state that doesn't have extra guaranteed issue rights, I'm wondering if we're going to see migration of those beneficiaries back into original Medicare, the ones that can afford a MedSup premium, which isn't everybody. But I wouldn't be surprised to see at least a bit of a shift in that direction, which will be interesting to watch because those are going to be higher risk people because they've been in Medicare Advantage for years. They're not coming in at age 65.
Yeah, no, that's a great point. I had the same thought that, for years and years, MA seemed like this unstoppable force, and we
Hmm.
are starting to see a recalibration. I think MedSup remains a really important alternative to Medicare Advantage. You know, we at the beginning of the year, we were looking at our crystal balls and predicting what is a new administration going to do with the regulations. One of the predictions was flexibility, that you traditionally see with a Republican administration as compared to a Democratic. So, potentially expanded flexibility for MA organizations, including more options for supplemental benefits. We also flag, anticipated rollback of policies from the Biden era. We predicted a possible reversal of the broker compensation restrictions, which have now been, as we've already mentioned, invalidated by a court. Possible rollback of the health equity index in star ratings and potential
And that
application.
that took a while, but that appears to be
Mhm.
happening underway.
Exactly. Deregulation, less emphasis on DEI initiatives. I think absolutely. We know from the proposed rule that even though the broker compensation restrictions have been invalidated, CMS is actively looking for guidance from stakeholders on how to regulate in this area. They want to know, how are plans engaging with FMOs, third-party marketing organizations, brokers. How can they pass rules that will sort of control the really outrageous compensation that was going to some of these larger organizations? And how can they do it compliantly?
And it sounds like the market is taking care of
Yeah,
some of that.
yeah.
In our discussion with Molly Turco in our third episode, we talked about just a resource constrained environment relative to, say,
Hmm.
10 years ago. And that's a good example, the broker commissions, that when you are in a less resource constrained environment and growth means growth and profitability, you're going to see different behavior in terms of broker commissions and supplemental administrative compensation and kind of pushing the envelope in that area. With some of those things, just the more constrained pricing models that the government is moving to is likely to, for better or worse, take care of some of those previous issues.
Yeah, and similar logic, I think, applies to supplemental benefits. Even though plans
Mhm.
might face less enforcement risk for offering creative and generous supplemental benefits, the financial pressures mean
Yeah,
that,
the
as a
money.
practical matter, they're rolling them back, and there are fewer supplemental benefits being offered this year.
Yeah. Yeah. Then risk adjustment is just a perennial challenge. The court striking down the risk adjustment rule with the extrapolation and the fee for service adjuster, that was a game changer.
That was something I never would have predicted in January. That
Yeah,
was a
that
shock.
was wild. That was wild. Did not see that coming. My understanding is they're still moving forward, at least with the 2019 RADV audits, but
Hmm.
we'll hear more, but we don't know. And CMS has now appealed that ruling, so that's an update. But yeah, that remains to be seen. I've never seen this much uncertainty in doing this work for over 20 years. I was kind of predicting based on my experience in the George W. Bush administration and the first Trump administration. I was expecting more growth and expansion and flexibility. I was kind of expecting more of that we saw in those eras, and that's not the vibe I'm picking up. I'm picking up just a lot of uncertainty and nervousness and contraction rather than
Hmm.
expansion. And I don't know, but I had a real expectation of that kind of growth energy, and that is not what has happened this year.
Yeah.
So it's something very different.
And it's unfortunate, right? That was one of our silver linings,
Mhm.
amidst all the uncertainty. Back in episode 1, we discussed how even with deregulation and decreased enforcement, litigation and compliance risks don't go away because they have a really long shelf life. Both the False Claims Act and the Anti-Kickback Statute outlast presidential administrations. And also, as you spoke to, Elizabeth, uh, regulations come back. All of the work that plans have been doing to comply with, new broker compensation requirements to prepare for a health equity index. Even though those things have gone away, it doesn't mean they're not going to come back in another form in 4 years.
And a colleague that I follow closely, for her LinkedIn insights, Melissa Newton-Smith, pointed out that health equity is always gonna be important
Hmm.
because you've gotta not just, like, from an ethical standpoint or altruism or good care, but you've gotta make sure your whole population is doing well to succeed in this market. So, no effort on that is in vain.
Yeah, and this is another silver lining. I think, this shift away from the language of equity, or DEI more generally, is an opportunity to refocus on what's important, which is outcomes and
Mhm.
access. And it doesn't really matter what you call your program. The thing is to do right by your members, all of them.
Mhm. Exactly, and if any group defined in any way is you're noticing in the data is struggling or behind or not getting everything that they need, call it what you want, addressing those needs is gonna be really important.
Absolutely. I do want to give a little bit of airtime to cybersecurity and resiliency. At the beginning of the year, we were coming off of the Change Healthcare attack and focus from CMS on cybersecurity to prevent these types of attacks and also resiliency after an attack. And, that of course remains a priority. But from my perspective, as a plan lawyer, the tech conversation was really dominated this year by AI. And I saw much less focus on security issues and a much greater focus on the evolving AI technology, how plans can use it, how they should be using it, how they may be required to use it. And I just want to encourage everybody who's listening that as you are negotiating with these really savvy new vendors, you can't get caught up in the hype around AI. You need to have all of your protections as a contract holder that you need to protect yourself in the event that there is a breach, at the downstream level.
Yeah. I'm glad we're talking about AI because I have sensed a shift from just wariness about AI towards realizing the value, the potential value that it brings, and thinking more about how to oversee it effectively. And I'll just say in our practice, this year has been transformative for me in terms of the way I am using AI, especially for research and analysis in a large pool of data that we search for answers. And really, I'm talking about legal research and analysis. I can get things done much more quickly. Of course, I validate everything that I'm getting back to the primary source, the government resource, the regulation, the memo, the guidance, the FAQ. I look at the actual thing. But AI makes me able to answer client questions much more quickly. And so I do have, just from my own first person experience, an appreciation for the potential value of AI and how it can make a human much more productive.
Yeah, I've been excited to see how the industry is using it in areas beyond utilization management, prior auth,
Mhm.
because that's where it's risky, and these are, really sensitive decisions that depend on individual circumstances, and that is a prime example of where you need like a human
Mhm.
overseeing every decision.
Human in the loop.
Human in
Yeah.
the loop, but that doesn't mean there's not other areas, right? Like customer service where AI can add a lot of value and streamline
Mhm.
your operations.
Yeah, yeah. I definitely have a bigger appreciation for how transformative and helpful it can be if it's just like anything else, if it's properly overseen by human beings.
Yeah, and your partners are willing to share in the risk that they
Mhm,
are creating for you. Because one of the things that I've seen is the gatekeepers of the AI tools,
mhm.
they know the limits of their capabilities, and they know they're very well aware of the legal risk, and they wanna put it on the health plan or the provider and disclaim all of it if they can, and I think
Yeah,
that's really not appropriate, where they are profiting off of the tool.
yeah, and it's really important for everyone. Like you need legal advisors who understand that, helping you with those contracts.
Absolutely.
Compliance teams need to understand that because it's not going to go. We can't just push it away. It's kind of like offshoring. There's going to be some offshoring, you know, and you have to rather than just try to keep it from ever happening,
Mhm.
unless I mean there are some environments where that's appropriate, but in most cases the best business approach is to figure out appropriate guardrails to address potential risks and to use it to be competitive.
Absolutely. I am just in the effort of keeping some structure to our conversation. I'm going to jump us ahead to, our second episode was really focused on the Inflation Reduction Act and the reforms to the Part D program. I think we have already covered that at length. And so episode 3, that was where we really started to get into a discussion that continued throughout the year on risk adjustment. We had our first guest, the wonderful and incredibly brilliant Molly Turco, former CMS, now is working as a consultant and she really, got like down in the weeds to talking about risk adjustment models and some of the work that she did at CMS and what she hoped to see continue under the new administration. And that, I think we can say risk adjustment is not an area where this Republican administration is going to say hands off, deregulation. They are
Mm-mm.
going to be they are making changes and they're going to continue to make changes.
Yeah, agree. I don't have anything I would look back from that discussion and say, "Oh, no, that didn't come to
Mm-mm.
pass," or "That's not still an issue."
One thing I just noticed, when I was looking back over my notes from that episode, we asked Molly to call out some of the proposals that she hoped CMS would finalize, and she mentioned changes to the prior authorization program, to utilization management, dual integration policies, improvements to the Medicare Plan Finder, and we did see a lot of that. CMS actually made changes to the Medicare Plan Finder without a proposed rule mid-year. It was sort of a
It's
rushed
choppy.
a rushed
It was
change.
choppy.
Yeah.
Yeah, it was rough. It was rough.
There were
The
some
provider
issues,
directory, yeah, there was yeah.
but now there's those enhancements. So beneficiaries should be able to look at provider directories as they're shopping for plans.
If they work,
Yeah.
I mean, so you are seeing some of the kind of move fast and break
Mhm.
things ethos being applied to, government health programs that can get, a little messy.
Absolutely. And they did, I think, in recognition of that, respond with a special election period for
Mhm.
members who made decisions, based on inaccurate information in the plan finder.
Yeah, yeah, all good, all good. It's funny, I had us down on episode 6, so
Oh,
I
you did?
wanted
Oh
to
my gosh,
yeah.
you've been
No,
moving us
I
forward this whole time.
no, you're just so thorough. My idea of covering something is very different than yours.
You know, and listeners who've worked with us will have certainly seen that dynamic.
Yeah, we
That's
touched
why
on
we're a
that.
good
We did.
team.
Yeah, absolutely.
Well, you know what? Let's talk about RADV audits then.
Yeah, let's do it. Let's do it. Yeah, that's been, well, we have touched on that. That's been a bit of a, whipsaw, hasn't
Yeah.
it?
Yeah, that's another example of a complete 180, right? In May, plans were looking at really existentially threatening RADV audits, covering years and
Using AI
years.
using AI to
Absolutely.
audit every plan for 6 years.
Yeah, and now that's on hold. Our recommendation has been, because these audits are still ongoing, is you just need to register that you disagree with any methodology that relies on extrapolation because that is currently not legal.
Yeah, it's amazing. Yeah, more to come on that. I mean, CMS won't let that go. Be seeing more rulemaking,
Hmm.
more litigation.
Possibly legislation.
Mhm. Absolutely.
So we had a really nice discussion with, I think, our second guest,
Mhm.
Charles Baker, on risk reform and responsibility. Charles has a compliance focus, and he came and gave really good insights into how to approach these questions of population health. From an operational perspective. And he talked about, when dealing with risk adjustment, the importance of integrating it with quality improvement and compliance, not just looking at it through a performance lens. And, I think no matter what happens with the audit methodology or with future possible changes to the risk adjustment program, that is going to remain important for plans. That risk adjustment is tied to patient care and quality improvement.
Yeah, those are words to live by in any regulatory environment.
Yeah, and any healthcare environment. Why are we
Mhm.
here? Who are
Yeah,
we
yeah,
serving?
yeah. Then we've touched on it, but talking about the market exits and a really, I think, sad reality behind some of these plans just closing down, that it's hard to sell a Medicare Advantage plan
Hmm.
right now if it's not seeing good financial results. That's a change. That's a development. Used to see more acquisitions as opposed to just departures. So it's kind of a sobering fact.
It is, although I think, we do expect there will be consolidations, I
Mhm,
think, going forward, but yeah, also just closures. And with
mhm,
that, we've had a lot of questions about the 2-year contracting ban in Medicare Advantage. Once an organization terminates all of its contracts, CMS doesn't let you just come back in with a new product right away without good reason. And so
with the same organization or common covered persons, this whole analysis.
exactly, right, and one thing that's worth noting is that the rules don't really contemplate the complex ownership structures that we have seen,
Mhm,
in
mhm.
this decade. So yeah, if that's something that you're looking at, it really does it's worth doing a close legal analysis and figuring out how that applies, if at all, to your organization.
In your specific situation
Mhm.
and, what your plans are for covering all of those run out obligations and long term, everything from document retention to how long you're going to need customer service to how would you effectuate an appeal decision that went,
Mhm.
through many levels and you find out in a couple years you had this obligation. So yeah, there's a lot there. So if you have business leaders who are even thinking of that as a possibility, help them understand the complexity so that they're prepared for the long range obligations following a departure from the Medicare plan market,
Yeah, and
which all can be addressed, and much of it can be delegated to vendors, and it can be done absolutely, but it takes some planning and intentionality.
yeah, and I was just gonna say, revisiting all of those ongoing responsibilities even after the plan terminates, just reminded me of the importance of having, robust transition services,
Mhm.
in your vendor agreements,
Yeah.
because the obligations, they don't go away. Even if,
Mm-mm.
even if you break up with a vendor, that, they're still gonna have, even if you close your plan, you've still got to
Mhm.
hold on to your records and do financial reconciliations. So it's really
Yep.
never too early to start thinking about it.
Absolutely. Yeah. And then that brings us to, we've already touched on the Texas court decision
Hmm.
vacating the risk adjustment extrapolation rule.
Yeah, that was episode 9 that we talked about that. I think we called it a legal earthquake. And I am really curious to see if that decision holds up on appeal. I don't think it's a given that it
Mhm.
will. But
No. No, I think, yeah, open question for
mhm.
sure.
But in the meantime, it was certainly a welcome reprieve for a lot of our friends in the industry.
Here's how I think about it. This is getting a little granular, but I suspect that that decision will be upheld
Mhm.
because it's based on procedural deficiencies that
Mhm.
can be pretty easily
Yeah.
cured with a new proposed rule. But I think once, assuming that plays out and a new rule is challenged and works its way through the courts on the substantive
Mhm.
grounds around extrapolation, I'd say that one was at least 50-50.
Yeah, once they get into the fee for service adjuster and actuarial equivalence, I
Mhm.
think,
Mhm.
the legal arguments are not as strong given precedent, from the Court of Appeals. And that, I think that's our wrap up. I wanna look a little bit into next year, now that we're in December. Is there anything that you are anticipating either as a major shakeup for the industry or not, or more of the same?
I'm going to be really interested to see, and this was true this year, the enrollment data
Mhm.
once we see how AAP went, see if there's growth, slowed growth, constriction, in terms of how many people are in Medicare Advantage. If we see migration back into original Medicare with Med Supp plans, I think that's going to be a very interesting data point to know where things are going.
Absolutely. Yeah, I know we appreciate the organizations that do that, data analytics.
Oh, yeah, it's great.
They're
Yeah.
wonderful. And then I'm interested in what's going to happen with the key TAM provisions of the False Claims Act. There's
Oh,
been
yeah.
a few courts now that have questioned their constitutionality, and I think the question is ripe for the Supreme Court soon. And, that will be a huge shakeup in terms of risk, legal risk to everybody with government lines of business in the healthcare industry.
Hmm. Also interested to see what comes through with these requests for information with this
Mhm.
proposed rule and what comes through Congress next year
Mhm.
is one trend that we're seeing. It's expressed a lot in the discussion over prior authorization and Medicare Advantage. It's just growing pains in the healthcare environment because of the rapid growth in MA over the past 15, 20 years and the aging of that population. So
Mhm.
if someone, turned 65 in 2010 and enrolled in an MA plan, hospitals weren't feeling that yet
Mm-mm.
because that person was pretty healthy. But now they're over 80 years old, and that's hitting home for the hospitals,
Mhm.
And so watching those demographics play out, those factors play out, providers getting more engaged around issues around Medicare Advantage, large health systems willing to go out of network and
Mhm.
just see where things shake out. That's new or increasing. So I think it's going to be a very interesting year to watch provider networks and the trends and providers flexing
Mhm.
a bit to use their leverage vis-a-vis Medicare Advantage plans.
Yeah, absolutely. I think that we'll continue to see some challenging contractual environments.
Yeah.
And just thinking about the aging population, one of the proposals in the No Upcode Act was, I believe, to disallow the use of like home health risk assessments for risk adjustment purposes. But as you have an older, more sicker population, those home health services and HRAs in general are really vital. So I
Can be
think,
helpful.
yeah,
Yeah.
they just
Can
got to
be
be
helpful.
deployed correctly.
Yeah. Yeah. What a year, Sandy.
It's been endlessly fascinating.
Yeah.
Thanks so much for doing this podcast with
Yeah, you
me. I've
too.
had a great
You
time.
too. Yeah, it's a good exercise.
And thanks to everybody for listening and sharing. We're just thrilled that people are enjoying it, and yeah, we can't wait to bring you more next year.
Yeah, thanks. Have a great holiday,
You too.
everybody.
Bye.
Bye. If you enjoyed this episode, please subscribe wherever you get your podcasts. And if you want to find out more, go to strategichealthlaw.com. This podcast is for informational purposes only and should not be considered legal advice. If you need legal advice on any topic we've covered, please consult an attorney with appropriate experience in health law. Our music is Galaxy Love by Johnny Duke. Until next time, thank you for listening to Health Law Simplified.